we shall be talking about the differences between a partnership and a company. People, they come forward, joint hands, enter into a business for the purpose of profit. It can be a partnership, it can be a company, but the basic motive of people coming together is to make profits out of it, out of the business venture. See, when I talk about a company, in this case, people come together, I told you, they contribute money for a business venture. No business can be carried on without the money. You have to contribute it or you have to take a loan for the same. Now, in the case of a company, people contribute their own money and then they share profits. Very simple. Similarly is the case of partnership. In this venture, people come together. They also contribute money for a business venture. Then they share the profits. So we see that this motive is the same, whether it is a company or whether it is a partnership. In the case of a partnership, generally few people as compared to a company. You can say it's a smaller scale. On a small scale, it's a partnership. Less number of people as compared to a company, and these people who join hands to share the profit, to start a business venture, they are generally old known acquaintances. Okay, it can be your relatives, it can be friends or friends of friends. This is how people form a partnership. Maybe I and you have a friendship of say 10 years or 5 years, and I know you are a trustworthy person, you are an honest person, and we both want to do some business, then we can enter into a partnership. So how do people, how do people enter into partnership? It is just their own acquaintances, they know each other, or the further friends of friends. This is how partnership usually comes into being. But when I talk about a company, there are comparatively larger number of people as compared to a partnership. The number is quite huge, and they are not known to each other. Here I told you that it is generally you know them, they are old friends or something like that. Here people are not known to each other. They are random people. Lot of people come together, and even after entering into a company, you may not be knowing each other. In case of a partnership, you know every partner. But here, the members, they may or may not know each other. Now, we start with the differences one by one in the tabular form. The first point is the Regulation Act, or the governing statute who govern the partnership and the company. A partnership concern is governed by a Partnership Act 1932. If at all the partners enter into a quarrel or a dispute or the working of the partnership in general, who will be the governing body here? The Partnership Act 1932. This will be the jurisdiction. In case of a company, it is governed by the Companies Act 2013. Whatever issue falls in this category, we will be referring to the Companies Act, and the jurisdiction will be given accordingly. Next point is the mode of formation or the registration. How will a partnership concern come into being, and so who will register a company? How will it be formed? Partnership is set up by an agreement amongst the partners. It can be any sort of agreement. Supposingly I and you enter into a partnership deed. It's between you and me. What type of agreement we want, what type of deal we want to frame. The profit sharing, it can be 50-50, it can be 60-40, 70-30, whatever suits you and whatever suits me. This is a closed cocoon between you and me. We can enter into any sort of partnership agreement. Okay, the registration of a partnership concern is not at all compulsory. But there are certain privileges which are given to the registered firms and which are not given to the unregistered firms. Please listen carefully. You can very well form a partnership without registration. Registration is not mandatory, but there are certain facilities which are given for the registered firms. Therefore, this Partnership Act indirectly encourages registration. Now, if you want to avail those privileges, kindly get it registered. Otherwise, you don't want to get it registered, no problem. You can go ahead like this itself. Coming to the case of a company, how is it set up? by the registration under the Companies Act 2013, and this registration is compulsory. You cannot form a company if you don't get it registered under this act. There are two stages in registering a public company. The first stage is called incorporation, and the second one is the commencement of business. A public company can start its business only after obtaining the certificate of commencement of business. You first obtain this commencement of business certificate, only then you are allowed to start your business. But if you talk of a private company, they can start a business just after obtaining this first certificate, which is the certificate of incorporation. So the Companies Act, it lays down certain different fundamentals for a public company as well as a private company. This I've just given it for your information. Here the topic is between the partnership and the company. So here the registration only is optional, but here it is very compulsory, and then there are further subparts of that registration, these two certificates. Next is the number of members. Partnership, minimum 2 members. Any 2 people can come forward and form a partnership. But in the case of a company, minimum 2 members in the private company. And in case of a public company, you need a minimum of 7 members, not less than that. When we talk of the maximum limit, it is 20 in case of any other business, and it is 10 in case of a banking business. So if you are entering into a partnership deed and your main business is the banking business, so the maximum people, they are 10, and any other business other than banking, maximum number is 20. Maximum number in the case of a private company is 50, and in a public company it is limitless. There is no boundary, there is no limit on to the number of members. You can go infinite number of members, that is the shareholders, in case of a public company. So you have to memorize these figures very well. Next is the property of the organization. See, if the partnership firm is having a property, it purchases a property, it purchases a land and building. The land and building of the partnership is the property of the members also. Supposingly we buy a machinery worth 10 lakh rupees and the partnership deed is between you and me. Now that machinery is of the partnership firm. Very good. That machinery is your machinery and that machinery is my machinery as well. So the property of the partnership firm or the property of the organization is the property of the members also. The property is of the firm and is the property of individual members as well. Just I gave you the example. But in case of a company, the property of the company is not the property, is the property of the company itself. It is not the property of the members. It is not at all the property of the members. A company's property is only a company's property. The members cannot claim that property. If it would not be so, supposingly if I have the shares of Reliance company, okay, and what a good idea, all the property of Reliance company is my property, then I will be just buying those shares only. Are you getting my point? Even if you have so many shares of that company, but the property of the company is of the company alone, company, not yours, even if you hold the shares of that company. But in case of a partnership, if you are into a partnership deed and the partnership firm is buying a land or a property or anything else, it is yours as well as that of the partnership firm. But in case of a company, the property of the company is of the company alone, not of its members. The members cannot claim that property. So this is a very big difference between the property of the organization related to company and a partnership. Next is the liability. The liability of the partners in a partnership deed is unlimited. The partners are jointly and separately responsible for the liabilities of the business. You cannot shoo away from the liability of a partnership firm saying that it is the liability of the partnership. No, it's your property, it's your liability as well. Just as I was telling you the property example, the property of the firm is your property as well. Similarly, the liability of the partnership firm is your liability as well. So what we say is that the liability of partners is unlimited. For example, if I join a partnership firm and it goes insolvent, To clear the partnership dues, they can attach even my personal property, my own house, my individual car. They can very well attach my own personal property to clear off the dues, to pay it to the outsiders. There is no limit. It is the same case of a sole proprietorship. When a sole proprietorship goes insolvent, all his personal property is attached. Similarly, in a partnership, if it goes insolvent, in the case of winding up, to clear the partnership dues, they can very well attach the personal properties of all the partners. So that is why I say that the liability of partners is unlimited. When we talk about the company, the liability of the shareholders is just limited. It is not unlimited. The company cannot come to the members to ask for money to pay off the creditors. Okay, now listen, the members are not personally liable for the obligations of the business. But here the partners, they were personally liable for the obligation of the partnership deed. But the members in a company, they are not personally liable. Now, when we talk about the limited partnership, what does this mean? It can be of two types. If company limited by shares, see, a member is liable to pay the unpaid amount on the shares. We have made a separate article regarding types of company according to its liability. You can go through, but here I'll just explain you. The members are liable to pay the amount on the unpaid shares. Supposingly, I bought shares of rupees 100 from a company. Okay, of rupees 100, I have these many shares. Now, I have already paid 40. The companies keep on asking for money, right? For application, for allotment, for first call and so on. Out of the 100 rupee share which I purchased, I have already paid 40. Now I will be liable to pay how much? Only 60 rupees if the company goes insolvent. If the company goes into liquidation, I repeat, I will be liable just to pay 60 rupees because I had the share of 100, 40 I have already paid. So what is the balance amount? Balance amount is 60, which I will pay to the company if the company goes insolvent. Beyond that 60 rupees, I will not pay a single penny to the company because my liability in this case is limited to the amount of share I hold. Okay, I hold the share of 100 rupees, but I'm not liable to pay 100 because 40 I have already paid. So my liability is limited to just 60 rupees. Is it clear? Second example is the company limited by guarantee. If I have given a guarantee for the company, I'll be liable to that amount only. I have given the guarantee of 1 lakh. I am liable to pay 1 lakh in the event of liquidation. The company cannot ask more than 1 lakh from me in case it goes into liquidation. To pay to its outsiders, I'll just have to pay 1 lakh because I have taken the guarantee of 1 lakh. So in this case, in the case of a company, the liability is limited. And these two cases I have explained it to you. But in the case of partnership, the liability is unlimited. Your personal property, personal assets, everything will be attached. Okay, here they cannot attach your personal property. They cannot ask for your personal assets. Nothing like this. Your liability is just limited. Okay, next point. It's the legal status. A partnership firm, it has no separate legal entity apart from its members. Partnership is not distinct from its members. अपनी खुद की पहचान नहीं है. This means like they don't have their own identity. They don't have their own separate legal entity. A partnership firm has no separate legal distinct entity. Whatever it is just due to the members. The members cannot enter into an agreement with the partnership firm. Why is it so? They cannot, because what is a partnership firm? It is not distinct. It is not separate. So the members, they cannot enter into any agreement with the partnership firm. The partnership firm is not a distinct legal person. No. Okay, but as far as a company is concerned, it has a separate legal entity. It is distinct from its members. It is separated from its members. The law, it considers company as a separate individual. It considers it as artificial person. उसकी अपनी खुद की पहचान है. It is separate. It has a common seal and it can enter into contracts by affixing its seal. If the seal of the company is there on any document, the company is binding by that. They don't need any of the members. They don't need any of the shareholders. The members of the company, they can enter into contract with the company. Here I told you the members, they cannot enter into an agreement with the partnership firm. No, they cannot. But here the members, they can enter into a contract with the company. A company is a distinct legal person. It is separate. It is separate legal entity. Clear? Next. Next comes the creditors. In a case of a partnership, the creditors of the partnership firm are the creditors of the partners. Did I tell you before? The property of the partnership firm is the property of the partners. The liability of the partnership firm is the liability of the partners. Similarly, the creditors of the partnership firm, they are the creditors of the partners also. The creditors are the creditors of the individual partners. Clear? Supposingly, a firm takes a loan from the bank can ask for the repayment of the loan from its partners. It has the authority because you are entering into a partnership firm. Whatever the loan, whatever the liability of your firm is, you are liable to pay, be it a bank loan, be it the creditors. The creditors of the partnership firm are very well the creditors of the individual partners as well. If you're sharing the property, if the property of the partnership firm is the property of the partners, similarly, the creditors of the partnership firm are the creditors of the individual partners as well. But when we talk of a company, the creditors of the company are the creditors of the company. That's it. They are not the creditors of the members. Is it clear? Supposingly a company takes a loan from the bank cannot ask the members to repay the loan. If I have shares of Reliance company, the bank cannot come to me and say that kindly repay the loan on behalf of this Mukesh Ambani. Na? No, they cannot, because my liability is limited. The creditors of the company are the creditors of the company. They are not my creditors. They cannot bother me, even if I hold the shares of that particular company. The company is responsible to repay it, not the members. The creditors, they cannot proceed against the members for the repayment. The members don't bother about the creditors of the company. The creditors of the company are the creditors of the company alone, not of the members. Company is responsible to pay it. Clear? Next. Next point comes the transfer of the shares or the transfer of the interest. Can you transfer your shares of a partnership firm or can you transfer the shares of a company? This is the point. See, in case of a partnership deed, the transfer is not permitted. It is not allowed. Please, you cannot transfer your shares. Supposingly, I enter into a partnership firm with you and tomorrow I say, oh my God, I'm not liking all this. Let me transfer it to my neighbor. No, you cannot. It's not allowed in the partnership deed. You cannot sell, you cannot transfer your share. If at all, a partner can transfer a share, that is only with the consent of other partners. I have to take the consent of each and every partner if I want to take this step forward. But generally, this is not allowed. This is not permitted. There needs to exist a separate clause for the partnership agreement for the same. If you want to transfer, in case of transfer or selling of your interest, there has to be a clear-cut partnership agreement given in the deed. Right? Now, when we talk of a company, a shareholder can sell his shares to whomever he wishes so. There is no binding, there is no restriction on the transfer of shares of a company. Okay, if I have 40 shares of any company, I can sell it to anybody and whenever I want to sell them. I don't have to take the permission of anybody, nor I have to tell or enter into a deed. Nothing of that sort. There is no binding, no restriction whatsoever. No consent is required. I don't have to take anybody's consent when I wish to sell those shares. I don't want anybody's permission. It is just my discretion when I want to buy the shares and when I want to sell off those shares. So it's so open in case of a company and it is not permitted in case of a partnership deed. Next point is the management and the control. A partnership concerned is managed and controlled by the partners. The partners have a right to participate in the administration of the business. Whatever business you are carrying on, the day-to-day working, any major decision, any minor decision, all that will be controlled. Everything is in the hands of the partners. Okay, but when we talk about of a company, it is not managed by the members. It is managed by the elected representatives of the shareholders, that is the board of directors. All the decisions will be taken, all the day-to-day activities, all the business ventures, your deals, it will be taken by the board of directors. A company is managed by the professional experts. Generally, we hire professional people to run a company. The shareholders cannot directly participate in the day-to-day working of the company. Supposingly, I have shares of Reliance company. I cannot go there and say, okay, let me take your decisions. I'll be taking the decisions because I have so and so shares. No, it's not allowed. The members, they cannot participate. Members here, I mean the shareholders, they cannot participate in the day-to-day working of the company, in any business venture, any deal, no, nothing at all. It's everything in the hand of the board of directors, and they generally hire the professional people to run that company. Next is the continuity and the stability. When we talk about the partnership firm, it gets dissolved on the death, insolvency, or incapacity of a partner. Supposingly there are 3 partners in a firm and unfortunately one of them died. The partnership firm comes to an end. It will automatically get dissolved if any of the partners get affected by the death or insolvency, or he becomes incapable. So all these factors automatically dissolution of the partnership deed. But in case of a company is stable. It continues on and on. It is not at all affected by the death, insolvency, or incapacity of any of the members. It does not affect at all. The company goes on. It's a very stable venture. The members, they may go on changing in the sense, it can be the death of the members, or it can be the selling of the transfer of shares also. Nothing will affect the existence of the company. It will not be affected by such things. If at all it will be affected when the company goes into liquidation. Then you can say that there is a full stop, not otherwise. But here the partnership is very well affected by the individual partners, and the company is not affected by its individual members. Okay. Next comes the statutory obligations. The partnership firm is not under statutory obligation for the compliance of any rules and regulations. Basically, a partnership deed is just managed by the partnership agreement into which all the partners enter into, and it is their discretion whatever terms and conditions they want to make it specify. It is no compulsion to maintain certain books. There is no compulsion to get the accounts audited, to publish the accounts, no need at all. The accounts of the partnership firm, they are audited at the discretion of the partners. If they want to get it audited, there is no problem. If they don't want to get audited, there is again no problem. There is no penalty on the partnership firm if the accounts are not audited. It's left to the discretion of the partners. But in case of a company, you have to maintain certain prescribed books. You have to get a periodical audit done. Some information has to be supplied periodically to the registrar of companies, which is mandatory for any company. Company is legally bound to have its accounts audited annually. If not, there rises a penalty which the company has to pay. Why is it so? This is because the money of the general public is being invested into the company. है ना? It's not their own money of the board of directors. No, people are contributing. People are buying the shares and debentures of your company. So what if you turn out to be a fraud? So that is why Indian Companies Act had made certain restrictions, because you are involved with people's money. People are investing in you. So for the safety, for the safeguard of that money, these restrictions are put on a company. That is why you have to get your accounts annually audited as well. Okay, so dealing with this point, there are so many statutory obligations which a company has to follow, and for partnership there is no such any statutory obligations. Okay, next point, mutual agency. Every partner is considered an agent of other partners. Now, what is the meaning of the word agency or agent? What you do is, supposingly you want to go on a holiday to Europe. What do? You generally, people, they visit a travel agent. What he does? He books the tickets for you. He books his hotels. Okay. And whatever is, he does it for you. Right. So here, every partner is considered an agent of others. In the case of traveling agency, you put your faith, है ना, in the hands of that agent, and he does the work for you in which you are bound. You have to pay for that and it will be yours. Similarly, in the partnership case, one partner is considered the agent of the other partner. One partner can do any act which will be binding on other partners. Partners are the agents of each other. They are the partners of, they are the agents of the firm as well. One partner can go and sign a document on the behalf of the firm. Okay, and it will be binding on all the partners. All the partners will be responsible for this. Supposingly I and you enter into a partnership deed, okay, and I enter into a contract with this Mr. X, okay, that I'll be buying this much raw material from you, and I sign it, and that's it. You are also a part of that agreement because I signed it. I am your agent. If I sign it, it has to be legally bound on you also, because I and you and me are in a partnership firm. Is it clear? Similarly, if you sign an agreement with any of the suppliers of the firm or any of the buyers of the firm, it is legally bound on me also. That is why we say that each partner is an agent of another partner. Okay, if supposingly I and you are in a partnership deal and I do some foolish behavior or I sign a foolish agreement, okay, still even if it is foolish, that is binding on you also. So that is why it is said, now choose your partners carefully. That is why if one partner is foolish, the foolish act will bind you as well. So I repeat that the partners are the agents of the firm, the partners are the agents of the partners as well. Whatever one partner signs, it will be legally bound on other partners as well. But a company or member is not an agent of any other member. No, even if I have a shareholders of Reliance Foundation, I cannot go and sign anything on the behalf of Mukesh Ambani. No, I cannot do that because a member is not an agent of the other members. Member is not an agent of the company also. The members of the company are not agents of each other. They are just the members. They are just the shareholders. Company cannot ask the members to go and sign a document on the behalf of a company. If you are a shareholder of a company, you are not authorized to sign any document which will be legally bound on the company. You cannot do that. Clear? Next. Authority. Authority of the members. Partner can bind the firm by his acts. As I told you, a partner can sign a document which will be legally bound on other members. So therefore, if I'm a partner in a partnership firm, I can bind the firm by my acts. I can bind the partners by my act by signing the deed. In a company, no, you are not authorized to bind the company. No, if you are a shareholder, you are just a shareholder, you are just a member, nothing beyond that. You cannot sign any document on the behalf of the company or on the behalf of other members. So the authority of the partners is way higher, but the members of the company, they don't have that much of authority. Next comes the winding up scene. What is this? Partnership concern can be dissolved easily. No legal formalities are required for winding up a partnership firm. If you want to wind up a partnership firm, okay, it can be done very easily. There are no distinct legal terms and formalities for the same. But in case of a company is wound up only through the court, it's a big thing. Okay, there are so many legal formalities. The court is satisfied and there is reasonable ground for winding up. Only then you can wind up a company. And for this also a proper procedure with legal terms has to be followed. Next, distribution of profits. The profits are distributed according to the terms and conditions mentioned in the partnership deed or equally if there is no agreement. Supposingly I and you enter into a partnership deed and we decide on 70:30 ratio. Okay, then nobody should have any problem in this case. We will be dividing the profit in the ratio of 70:30. It can be 85:15, it can be 50:50, it can be 40:60, whatever we decide, that will be the final deal. And if there is no agreement, in that case, a partnership deed, partners have to equally distribute the profit. But in case of a company, it depends upon the articles of association or the directors as to what share of profits will be distributed to the shareholders. How much profit? This is called a dividend. The profit which is given to the shareholders is called dividend. Now, how much dividend will be given to the shareholders? That has to be decided either upon the articles of association or the board of directors will decide it. Clear? Next comes the business. Partnership can carry on any business if all the partners agree. Supposingly I and you are entering into a partnership agreement, into partnership deed, and we decide to deal in tires. Okay, we can deal in tires. If we want to deal in bed sheets, okay, we can deal in bed sheets. So it's just the mutual consent of the partners. We can go and run any business in a partnership deed. Clear? Now, in case a company can carry on only that business which is permitted by the object clause of Memorandum of Association. Now, what is the Memorandum of Association? We have made a separate article for that. You can kindly go and have a look. Whatever is mentioned there, the company just can enter into that business. It's not ki today morning, okay, we'll deal in curtains, and the next day we'll deal in furniture. No, it's not like that in case of a company. Whatever has been written in the MOA, Memorandum of Association, you have to go by that only. Next point is the dissolution of the organization. How will you dissolve it? Partnership deed is the result of an agreement, and it can be dissolved anytime by an agreement, anytime. When the partners think that they don't get along or any other reason, the partnership firm can be dissolved. Supposingly me and you, we start fighting. You don't like my tantrums. I don't like your behavior. We can agree, okay, come on, finish it off. We are not getting along. It's okay. You can do that. There is no lamba chauda. There are no legal formalities. No hassle. Okay. So anytime we can dissolve it. But in case of a company, it is created by law. I told you in the beginning, and hence it has to be dissolved by law. Okay, it is legally dissolved, and you have to abide by so many formalities of the ROC. It's not an easy task. There are so many hassles and legal formalities for the same. Okay, so here we come to the end of the article. I hope I have made the things very clear to you. In case you have any doubts, please feel free to ask me in the comment section. If you want to give me any suggestion, please feel free to write in the comment section. Kindly like and subscribe to my channel. Thank you for watching. Stay safe, stay blessed.